The letter arrived on a Friday afternoon in March, sandwiched between a utility bill and a pizza coupon, and I almost missed it entirely. When I finally opened it that evening at the kitchen table, I read it 3 times because I was certain I was misunderstanding something. The Stonegate Crossing HOA was informing me that effective April 1st, all residents utilizing garage spaces would be required to pay a monthly community space access fee of $150. My garage, the one described in my deed. The one I'd paid for when I paid $342,000 for my house 6 years earlier. The one where I kept my workbench and my tax files and Jill's gardening tools along the south wall. They were charging me $150 a month to use my own property. I set the letter down, opened my laptop, and pulled up the Cobb County Property Records database. I'd been a CPA for 22 years. I knew what a number that didn't belong looked like. And I was already starting to understand that $150 a month was just the number they'd decided to show me. My name is Randall Kuster. Most people call me Randy. I'm 49 years old and I run a small CPA practice out of a home office in Kennesaw, Georgia, handling tax preparation, small business accounting, and financial consulting for about 60 regular clients.
I've been doing this work since I was 27, which means I've spent more than 2 decades looking at financial documents the way a mechanic looks at an engine. Not for what they say they are, but for what they actually show. Numbers have a logic. When the logic is broken, you can feel it before you can prove it. The way a house settles differently when something in the foundation isn't right. Jill and I bought the house at 4417 Stonegate Crossing Drive in November 2017.
She teaches 4th grade at Altry Middle School in Marietta and has the particular combination of patience and low tolerance for nonsense that 20 years of managing children in groups of 25 will produce in a person. We'd been married 16 years by then, had raised our daughter Caitlin in a smaller house in Smyrna, and decided when Caitlin left for University of Georgia in 2016 that we'd use the equity to buy something with a little more space and a yard worth having. The Stonegate Crossing house had 4 bedrooms, a screened back porch, and a 2-car attached garage that the listing described as a premium feature and that the appraiser had valued as part of the property at $38,000 in assessed contributory value. The garage mattered to us in specific ways. I'd spent 18 months converting a section of it into a proper home office overflow space, with a workbench along one wall, shelving for archived client files going back 7 years, and a small HVAC split that kept it climate-controlled year-round. Jill had the other section organized with the precision she applies to everything: 3 years of seed packets and garden tools, and the kind of careful equipment accumulation that happens when someone takes a hobby seriously over time. We'd invested real money in those improvements. The garage wasn't storage, it was part of how we lived in that house. Stonegate Crossing was 94 homes built between 2009 and 2012, spread across 3 cul-de-sacs and a main loop road. The HOA had been operating since the development's completion, governed by a board of 5 members elected annually by residents. Annual dues were $2,400, paid monthly at $200, covering common area maintenance, the community entrance landscaping, a small pool and clubhouse, and street lighting. For most of our time there, the association had been functional and largely unremarkable. The previous president, a retired Delta pilot named Sam Brower, had run things with the quiet competence of someone who understood that the goal was a well-maintained neighborhood, not a demonstration of authority. Douglas Fenn had been HOA president for 2 years when the garage letter arrived. He was 65, a former real estate developer who'd spent most of his career building mid-size commercial and residential projects across the Atlanta metro area before a 2016 venture into a mixed-use development in Cherokee County had failed with considerable financial consequences that were, according to the Cobb County courthouse records, I'd later pull for entirely different reasons. Still working their way through litigation when he moved into Stonegate Crossing. He was heavyset, with the careful grooming of someone who'd spent decades in client-facing roles, and he drove a 2023 Mercedes GLS 580 in obsidian black that he parked in his driveway rather than his garage, a fact I'd noticed without registering its significance until later. Fenn had run for president on a platform of community enhancement and professional management, which had sounded reasonable enough that he'd won the election by a comfortable margin. In his first year, he'd overseen a legitimate improvement to the community pool facilities and renegotiated the landscaping contract to a lower rate. He'd also begun expanding the scope of HOA enforcement in ways that were incremental enough to not trigger organized resistance. New paint color guidelines with a narrower approved palette. A revised vehicle policy that restricted commercial vehicle parking more broadly than the previous rules. A maintenance fee increase of $40 per month that the board had passed at a sparsely attended summer meeting. None of these individually was dramatic enough to be worth a fight. Collectively, they established a pattern I'd noticed but hadn't yet understood as a pattern. That's the thing about incremental overreach. Each step looks like a policy decision. It takes a certain kind of professional attention to see the direction the steps are going. The garage letter was not incremental. The garage letter was a leap. I read it a fourth time after Jill came into the kitchen, and she read it over my shoulder without speaking for a moment. "Tell me I'm reading this wrong," she said. "You're not. They're charging us rent for our garage. That's what the letter says." She sat down across from me. Jill has a particular expression she uses when processing something she finds genuinely unbelievable. A slight narrowing of her eyes combined with a stillness that means her internal monologue is working through the implications faster than she's ready to speak them. I've been watching that expression for 23 years of marriage, and it never means anything good for the person who caused it. "Randy," she said, "that garage is in our deed." "I know. I was there when we closed. The appraiser valued it separately." "I know that too." She looked at the letter again. "What are you going to do?" I turned the laptop toward her so she could see the Cobb County Property Records database open on my screen. "I'm going to read every document that has our address on it," I said, "and then I'm going to understand exactly what they think they're doing and whether they have any legal basis to do it." I was at the laptop until 1 in the morning. What I found in those 4 hours established the foundation of everything that followed. The deed for 4417 Stonegate Crossing Drive, recorded at the Cobb County Superior Court Clerk's Office on November 14, 2017, described the property as follows: a residential dwelling of approximately 2,847 square feet, situated on a lot of 22 acres, together with a two-car attached garage as an appurtenant structure to the primary dwelling, all as shown on Plat Book 3112, page 47, Cobb County Records. Appurtenant structure. Those two words are not decorative under Georgia property law. An appurtenant structure described in a deed is a component of the freehold estate conveyed by that deed. It belongs to the property owner. Period. Full stop. No HOA, regardless of what its bylaws said or what its board decided, could reclassify an appurtenant structure described in a recorded deed as community property without the owner's consent and a new recorded conveyance. I pulled the HOA's CC&Rs next. The original document, recorded in 2009 when the development was established, defined community property as all common areas, shared amenities, and infrastructure serving multiple units, specifically excluding individual dwelling units and their appurtenant structures. The garage was by the HOA's own founding documents, not community property. Then I found the amendment. In December 2019, the HOA had adopted an amendment to the CC&Rs redefining the term community space to include all enclosed parking structures within the development, regardless of physical attachment to individual dwelling units. The amendment was signed by Douglas Fenn as president and 2 other board members. It was dated December 14, 2019. I looked at that amendment for a long time. Then I opened the Georgia Property Owners Association Act, specifically OCGA Section 44-3-227, which governs amendment procedures for HOA governing documents. The statute requires that any amendment affecting property rights of individual owners must be approved by a vote of at least 67% of all association members, not just board members, and must be preceded by written notice to all members at least 30 days before the vote. The notice must specifically describe the proposed amendment and its effect on member rights. I searched the HOA's records, accessible through the Cobb County Property Records System, for any notice of a 2019 membership vote on CC&R amendments. I found nothing. No notice, no vote record, no meeting minutes reflecting a membership vote. The amendment had been signed by 3 board members and recorded as if it were a valid bylaw change. Under OCGA Section 44(3)(227, it wasn't. The amendment was procedurally invalid. The legal basis for the entire garage fee program had never existed. I sat back in my chair at 1 in the morning in my kitchen in Cobb County, Georgia, and did what CPAs do when they find something that shouldn't be there. I started calculating if Fenn's intention was to charge $150 per month per garage starting April 1st, and if this scheme had been contemplated for some time, had similar fees perhaps been applied before. I went back through my own HOA payment records, which I keep meticulously because I'm a CPA, and the idea of not keeping meticulous financial records is physically uncomfortable to me. Our dues had increased $40 per month in the summer of Fenn's first year. The stated reason was enhanced maintenance services. I pulled the HOA's annual financial disclosures, which they were required to provide to members under OCGA Section 44(3)(232. I cross-referenced the disclosed maintenance expenditures against the fee increases. The numbers didn't reconcile. Over 2 years, the HOA had collected approximately $45,000 more in dues than could be accounted for by the disclosed maintenance expenditures. This wasn't definitive proof of anything specific, but it was a materiality threshold that, in an audit context, would have required explanation, and it suggested that the garage fee wasn't a new idea. It was a new formalization of an approach to revenue collection that had been operating less explicitly for at least 2 years. I went to bed at 1:15. I didn't sleep particularly well. The following Monday, I sent the HOA a written response to the garage fee notice, via certified mail, stating that I would not be paying the fee, that my garage was described as an appurtenant structure in my recorded deed, that the 2019 CC&R amendment purporting to reclassify garages as community spaces was procedurally invalid under OCGA Section 44(3)(227, and that any attempt to assess fines or place liens on my property would be contested on these grounds. The letter was professional and specific and cited statutes by number because I wanted Fenn to understand immediately that the person he was dealing with had read the relevant documents. Fenn's response arrived 8 days later. It was 2 pages long and it was wrong in almost every particular. It claimed the 2019 amendment had been properly adopted. It claimed the HOA had authority under its governing documents to classify and manage all parking structures. It claimed my deed description did not override the association's community property designations. It threatened daily fines of $25 per day beginning 30 days from the original notice date and stated that the HOA reserved the right to place a lien on my property for unpaid assessments under Georgia HOA lien provisions. I read the letter twice, then I called Sarah Kim. Sarah was 40 years old, a real estate and HOA attorney operating out of a 3-person firm on South Cobb Drive in Marietta. She'd been practicing HOA law in Cobb County for 14 years. A colleague of mine had used her in a commercial property dispute 2 years earlier and described her as methodical and unimpressed by bluster, which was exactly the combination I needed. I got her on the phone that afternoon and spent 20 minutes laying out what I had. She asked 6 questions, all of them precise, and then said, "Can you come in Thursday?" I brought the folder to her office Thursday morning. She reviewed everything for an hour while I sat across from her conference table and watched her read the way I read financial statements, not performing attention, but actually paying it. When she finished, she looked up. "The amendment is void," she said. "Not voidable, void. OCGA Section 44(3)(2027 is not a suggestion. The notice requirement and the membership vote requirement are mandatory procedural prerequisites. An amendment adopted without them has no legal effect regardless of how it was recorded. Your garage is not community property. It was not community property when you bought the house, it was not community property after the 2019 amendment, and it is not community property now. What about the fines and the lien threat? The fines are based on the fee, which is based on the amendment, which is void. The lien threat is based on the fines. The whole structure collapses at the foundation. She paused. Do you know whether other residents received the same notice? I've talked to 3 neighbors. All 4 of us with 2-car garages got it. There are 61 2-car garage units in the development. She was quiet for a moment. Randy, do you understand what 61 units at $150 a month represents over a year? $109,800, I said. I'd done the calculation before I came. And if the intent was to collect this for multiple years, which the structure of a monthly recurring fee suggests, the potential total collection over 5 years would be approximately $549,000, plus the unexplained 2-year surplus I found in the financial disclosures, which adds approximately $45,000 to the picture. Sarah looked at me for a moment. How long have you been a CPA? 22 years. Does it bother you when numbers don't reconcile? Physically, I said. She almost smiled. I'm going to write a formal demand letter to the HOA board, citing the void amendment and the deed language and the relevant statutes. I'm also going to notify them that the financial discrepancy you've identified warrants a full accounting and that we reserve the right to pursue class action claims on behalf of all affected residents if the board doesn't respond appropriately. She paused.
There's one more thing I want you to do. I want you to pull the public corporate filings for the Stonegate Crossing HOA. It's registered as a nonprofit under Georgia law. I want to see the full corporate record. I pulled the Georgia Secretary of State corporate filings that evening. The HOA was registered as a Georgia nonprofit corporation, as most HOAs are. Georgia nonprofit corporations are governed by the Georgia Nonprofit Corporation Code, OCGA Title 14, Chapter 3.
The code imposes fiduciary duties on directors and officers and specifically prohibits transactions that benefit officers or directors at the expense of the corporation without proper disclosure and board approval. I thought about Douglas Fenn's Mercedes in the driveway instead of the garage. I thought about a real estate developer who'd lost significant money in a 2016 development failure and was now running an HOA that was generating unexplained revenue. I thought about an amendment that appeared to have been signed by 3 board members without a membership vote, creating a recurring fee program affecting 61 units. And I thought about one more thing I'd noticed in the financial disclosures that I hadn't mentioned to Sarah yet because I wanted to verify it first. The HOA's 2021 and 2022 financial disclosures showed a line item labeled Administrative Management Services totaling $67,000 over 2 years. The vendor was listed as Fenn Property Management, LLC. I looked up Fenn Property Management, LLC in the Georgia Secretary of State database. The registered agent was Douglas M. Fenn, 4389 Stonegate Crossing Drive, Marietta, Georgia. Fenn had been paying his own company $67,000 in HOA funds for management services. The board meeting minutes I could access showed no disclosure of this relationship and no recusal by Fenn on the votes approving those payments. I called Sarah the next morning at 7:30. She was already at her desk. I told her what I'd found. She was quiet for a long moment. When she spoke, her voice had a different quality, the particular focus of an attorney who has just seen the case change shape. Randy, she said, this isn't just a void amendment and an improper fee anymore. What you're describing is a pattern of self-dealing by an HOA officer that potentially violates Georgia nonprofit corporation law, Georgia HOA statutes, and depending on how the funds were characterized and reported, possibly state tax laws. This is something the Georgia Attorney General's Consumer Protection Division needs to know about. How do we get it to them? I file a formal complaint with documentation. But first I send the demand letter to the board because we need to give them the opportunity to respond appropriately before we escalate. And I'd strongly recommend that before we do either of those things, you talk to your neighbors, not just the 3 you've already spoken to, all of them, because the strength of a consumer protection complaint goes up considerably when it's not 1 resident against an HOA, but 61 residents who've all been subject to the same scheme. I talked to Jill that evening. She listened to the full picture, from the void amendment to the Fenn property management payments, without interrupting. When I finished, she said, "So he's been stealing from the neighborhood." "That's the accurate characterization," I said. "How much?" In total, between the unexplained fee surplus, the management payments to his own company, and the proposed garage fees if they'd been collected for the intended period, somewhere in the range of $600,000, maybe more, depending on what a full audit finds. She looked at me. Randy, people need to know about this. I know. Not just our neighbors, people who read the news. I'd been thinking about that. The question wasn't whether the story was newsworthy. It obviously was. The question was whether going to the media before the legal process was in motion was the right sequence. I called Sarah back and asked. She said, file the complaint with the AG's office and give the board the demand letter. Then talk to whoever you want. The facts are in public records. That's what public records are for. The demand letter went to the board on April 8th, certified mail to each of the 5 board members individually. 14 pages. The void amendment. The deed language. The statutory requirements Fenn had ignored, the financial discrepancy, the Fenn property management self-dealing, the demand for immediate cessation of the garage fee program, a full independent audit of HOA finances going back to January 2020, and a written response within 15 business days. Sarah had written it with the precision of someone who understood that every line would eventually be read by someone other than the board. In the meantime, I started talking to neighbors. My first call was to Carol Whitman at 4428, directly across the street. Carol was 58, a retired hospital administrator who'd lived in Stonegate Crossing since 2011, and who I'd always found sharp and observant in the way of people who've spent careers managing complex organizations. I knocked on her door on a Saturday morning, showed her the demand letter summary and the key documents, and asked if she'd received the garage fee notice. She had. She'd been paying it for 3 months already, having assumed it was legitimate. She'd paid $450 in garage fees she should never have owed. When I showed her the deed language and the void amendment analysis, she sat at her kitchen table for a moment without speaking. Then she said, "How many other people have already paid this?" I didn't know yet. Over the next 2 weekends, Jill and I knocked on doors. Not every door. I targeted the 61 properties with 2-car garages that had received the fee notice, working through them systematically with a clipboard and a summary sheet Sarah had helped me prepare that explained the situation in plain language without legal jargon. Of the 61 properties, I reached 43 owners directly. 27 had already begun paying the fee, most of them assuming it was a legitimate HOA assessment they couldn't avoid. Total payments already made by residents I could confirm, $17,400 in 3 months. The community meeting happened on a Wednesday evening at the Stonegate Crossing Clubhouse, 19 days after I'd started knocking on doors and 16 days after the demand letter was delivered to the board. 38 residents showed up, which was more than had attended any HOA meeting in the development's history as far as anyone could remember. I'd reserved the clubhouse through the standard process, paying the $75 rental fee with a check I made sure to get a receipt for. I'd prepared a presentation. 12 slides printed as handouts, with the key documents included as appendices. The deed language, the original CC&R definition of community property. The 2019 amendment with the procedural deficiencies highlighted. The OCGA Section 44-32227 requirements. The financial discrepancy analysis. The Fenn property management payments with the Secretary of State registration showing Fenn as the registered agent. All of it sourced to public records. All of it documented with the specificity you develop when 22 years of accounting work has trained you to understand that evidence is only as useful as its chain of custody. Douglas Fenn showed up at that meeting. I hadn't expected him to, but in retrospect I understand why he did. He'd been told about it, obviously, and the calculation he'd made was that his presence would be intimidating enough to control the room. He stood in the back with his arms crossed and said nothing for the first 40 minutes while I went through the presentation. The room got quieter as I went through each slide. The particular quiet of people understanding something they hadn't understood before and processing what that meant. When I got to the Fenn property management slide, someone in the 3rd row said out loud, to no one in particular, "He's been paying himself with our money?" I said. "That's what the public records show." Fenn spoke for the first time. Those payments were for legitimate management services provided to the association and were approved by the board. I looked at him from the front of the room. Mr. Fenn, were those payments disclosed to the full membership as a related party transaction? Was your ownership of the vendor company disclosed to the board before the votes approving those payments? Were you recused from those votes? Because I've reviewed the available board meeting minutes and I don't see evidence of any of those things. He said the minutes were incomplete records and didn't reflect everything that had occurred in board meetings. I said the association was required under OCGA Section 44 to 323-2 to maintain accurate records and make them available to members, and that the records available showed no disclosure and no recusal. The room was very quiet. Pete Dunbar spoke next. Pete was 52, a board member who'd served for 3 years and who'd been sitting in the front row with an expression that had been getting more uncomfortable as the presentation progressed. He said, "I want to be on record that I was not aware of the ownership relationship between Douglas and Fenn Property Management when I voted to approve those management contracts. That relationship was never disclosed to me." Fenn started to respond. Pete cut him off. "I'm also not satisfied with the explanation for the 2019 CC&R amendment process. I was on the board at the time, and I don't recall a membership vote being held. The meeting lasted 2 hours. By the end of it, 31 of the 38 residents present had signed a petition requesting an emergency board meeting, a full independent audit, and the immediate suspension of the garage fee program pending legal review. Carol Whitman had offered to coordinate a spreadsheet tracking which residents had already paid the fee and in what amounts. A man named Victor Osei at 4,403, who'd paid 5 months of garage fees totaling $750, said he wanted to be the lead plaintiff if this went to class action. I told him to call Sarah Kim. I called Tom Belsky the following morning. Tom was 33 years old and worked as a staff reporter at the Marietta Daily Journal, a local paper that covered Cobb County government, business, and community news. I'd read his byline enough times to know he covered HOA and property disputes as part of his municipal beat and understood the legal landscape well enough to write about it accurately. I sent him an email at 7 a.m. with a subject line that read, "Stonegate Crossing OA has been charging rent for privately owned garages." Below the subject line, I put a 1-paragraph summary and offered to provide full documentation. He called me at 9:15. We talked for 40 minutes. I sent him the document package Sarah had assembled, the same materials I'd presented at the community meeting, all sourced to public records. He asked good questions, the kind a reporter asks when he's already seen enough to know the story is real and is filling in the gaps rather than testing the premise. He said he'd reach out to Douglas Fenn for comment and to the HOA's attorney if they had one. He said he'd also be submitting his own public records requests for the full HOA financial filings. The story ran 6 days later on a Thursday, front page of the Marietta Daily Journal's local section, with the headline, "Cobb County HOA charged residents rent for their own garages." Tom had done his reporting thoroughly. He'd obtained Fenn's comment, which was a statement through an attorney saying the HOA disputed the characterization of events and stood by the validity of its governing documents. He'd included the deed language, the void amendment analysis, and the Fenn property management relationship. He'd spoken to Carol Whitman, who was quoted saying she'd paid $450 before she understood she never owed it. He'd gotten a statement from a Georgia HOA law expert at Georgia State University confirming that an amendment adopted without the required membership vote under OCGA Section 44.3/2027 had no legal effect. The story was picked up by the Atlanta Journal-Constitution 2 days after the Marietta Daily Journal ran it. The AJC ran a shorter version with a focus on the AG complaint angle, noting that the Georgia Attorney General's Consumer Protection Division had confirmed it had received a complaint related to the matter and that a review was underway. I hadn't expected the AJC pickup. Jill showed it to me on her phone on a Saturday morning, and I sat with that for a moment, the feeling of something that had started as a letter on a Friday evening, becoming a story that 60,000 people in Metro Atlanta were reading over their coffee. What changed after the story ran is easier to describe as a sequence than as a narrative. Douglas Fenn resigned from the HOA presidency on the Tuesday after the AJC story, citing personal reasons in a 1-paragraph letter submitted to the board. His attorney contacted Sarah that same day to open discussions about a resolution. The board, now operating without Fenn and with Pete Dunbar serving as acting president, voted unanimously at an emergency meeting to suspend the garage fee program immediately and to commission an independent audit of HOA finances going back to 2019. The audit took 6 weeks and was conducted by a Marietta accounting firm with no prior relationship to the HOA. What it found confirmed and extended what I'd calculated from the public records. The Fenn property management payments, $67,000 over 2 years, had been approved without proper disclosure and constituted self-dealing under Georgia nonprofit corporation law. The $45,000 in unexplained fee surplus I'd identified had partially funded those payments and partially accumulated in accounts that had been used for expenditures the audit characterized as inadequately documented. The garage fees collected in the program's 3 months of operation totaled $22,800 from 61 units at varying payment rates. The Georgia Ag's Consumer Protection Division completed its review and issued a civil investigative demand to the HOA and to Fenn personally in August. The CID required production of all financial records, all board minutes, and all communications related to the garage fee program and the Fenn property management contracts. Fenn's attorney negotiated for 6 weeks before a consent agreement was reached in which Fenn personally agreed to repay $67,000 to the HOA representing the management payments, to pay a civil penalty of $28,000 to the state, and to be permanently prohibited from serving as an officer or board member of any homeowners association in Georgia. The consent agreement was public record, and I read it 3 times. The civil class action that Sarah filed on behalf of 39 Stonegate Crossing residents who had paid the garage fee was resolved in a settlement that included full refunds of all fees paid, totaling $22,800, plus $15,000 in additional compensatory damages for the class, plus legal fees. The HOA's insurance carrier funded most of the settlement. Individual checks went out in October, and Carol Whitman, who had organized the payment tracking spreadsheet with the precision of a retired hospital administrator, confirmed to me when the last check cleared that every claimant had been made whole. The total financial accountability of the scheme, adding Fenn's personal repayment to the HOA, the AG civil penalty, the class action settlement, and the audit costs, came to approximately $148,000. Not the $600,000 maximum exposure I'd calculated if the scheme had run to completion, but enough to represent a genuine consequence. The independent audit's findings were provided to the Cobb County District Attorney's Office, which opened a review that, as of the last I checked, remains ongoing. I don't control what happens there, and I don't think about it much. That's the DA's domain, not mine. Douglas Fenn no longer lives in Stonegate Crossing. His house went on the market in September and sold in 31 days to a family from Dunwoody who, as far as I know, had no idea what had happened there. I don't know where he went. I don't particularly care. The HOA board election in November returned 3 new members, including Carol Whitman, who ran on a transparency and accountability platform and won by the largest margin in the development's history. Pete Dunbar, who'd been the first board member to break publicly from Fenn at the community meeting, was elected to a full term and became the new president. The board's first action was to adopt a financial transparency policy requiring quarterly disclosure of all expenditures above $500, including vendor relationships and any connections to board members or officers. I'm sitting in my garage right now at the workbench along the south wall on a September evening with the door open to let in the cooling air that Georgia finally delivers in the fall after months of heat. My client files are on the shelves where they've been for 6 years. Jill's garden tools are in their section along the north wall. The split unit I installed is running quietly, everything exactly where it belongs. I've thought a lot about what made this particular situation what it was. Not just the specific facts, the void amendment, the self-dealing, the undisclosed payments, all of which were genuinely serious, but the underlying dynamic that allowed it to get as far as it did. Fenn had made a calculated assessment that most people, when faced with an HOA fee notice that appeared to come from legitimate authority, would pay it rather than fight it. That calculation wasn't entirely wrong. 27 of 61 households had already paid before anyone pushed back. Most of them had assumed the fee was legitimate because it came on official letterhead from an organization with apparent authority. They paid $150 a month for something that was already theirs. The thing a CPA understands, that I think not everyone does, is that apparent authority and actual authority are not the same thing. An organization can have real authority over some things and no authority over others, and the letter it sends you doesn't tell you which category you're in.
The deed tells you, the statute tells you, the source documents tell you, the letter tells you what someone wants you to believe, which is a different thing entirely.
Jill brought me a cup of coffee out here about an hour ago, stood in the garage doorway for a moment and looked at the space, the way you look at something you almost lost. "You know what I keep thinking about?" she said. "What's that? All the people who paid it and never said anything. Not because they were okay with it. Because they didn't know they had a choice." She's right. That's the part that stays with me. Not the $150, not the void amendment, not even the self-dealing that turned out to be at the center of it. The part that stays with me is the 27 households who got a letter on official letterhead demanding money for something that was already theirs, and who reached for their checkbooks because that's what you do when authority tells you to. Not because they were passive or uninformed, but because the system looked legitimate, and because nobody had told them yet that the document in their deed drawer had more authority than the letter in their mailbox. That's what I want people who hear this story to take from it. Not that HOAs are uniformly corrupt, because they're not. Not that you should refuse every assessment that comes your way, because that's not right either. But that your deed is a legal document that describes what you own, and that no letter on any letterhead from any organization can change what that document says without a legal process that changes the underlying record. The record says what it says. If someone tells you otherwise, the first thing to do is pull the record and read it yourself. My garage is 460 square feet. 2 cars, a workbench, a set of shelves, a climate control system, a 6-year history of my work life organized and filed in sequence. According to Plat Book 312, page 47, Cobb County Records, it is an appurtenant structure to the primary dwelling at 4417 Stonegate Crossing Drive. It belongs to me. It has always belonged to me. It will continue to belong to me, and it costs me exactly nothing per month to park in it.
If you've ever gotten a bill for something you already owned or been told by someone in a position of apparent authority that the thing described in your deed wasn't actually yours, I'd genuinely like to hear about it. What did you do? And how did it come out? Leave it in the comments. I read everyone.